This business advising session is being presented by the Illinois Restaurant Association in partnership with the Cook County Small Business Source. Established to ensure businesses emerge from COVID-19 intact and positioned for growth, the Small Business Source connects small business owners with expert guidance and support. Services include no-cost business advising, resources, and events that connect small business owners with a community of advisors. If you're interested in one of our advisors reaching out one-on-one for further business advising, sign up at cookcountysmallbiz.org. It's free and easy to sign up. For today's business advising session, we encourage you to ask questions. We'll have a Q&A session at the end of the presentation, and at that time, you can come off of mute and ask your question or post them in the chat. We also have a team from the IRA here today to assist with further questions. At this time, I'd like to introduce our panelists, William Schiller and Ian Wagreich, partners at Hinshaw and Cuthbertson Law. Gentlemen, please take it away.
Great, thank you for that introduction. Bill and I, as you can imagine, these days we've really been fielding a lot of calls from employers. Some of them have had visits from the government, but mainly a lot of them really it's, hearing on the news what's happening in terms of government raids and what do we do? How do we protect ourselves? And after, after there is a government raid, what can we do to help our employees? So we're going to talk a lot about those sorts of things. And we won't spend too much time on the presentation because we did want to leave plenty of time for a Q&A. I'm going to some of this will be a review from the last really excellent presentation that the Illinois Restaurant Association gave on this subject, but I think it really bears reinforcement for those of you who were at the previous presentation, and then it helps to give you the background, the necessary background.
Ian, can I just step in and say something?
Yeah, wanted to jump in.
And we've got and I said it on the last session, it was great. The key is we need to have a foundational understanding of things, and the bottom line is do things correctly. And what I've been doing is, you get bombarded with news every day. They're talking about executive actions being announced more this week. Obviously it's coming. And what I've been doing, and Ian as well, is, and we're kind of a tag team here, and we'll explain how we do things. What I've been doing is having calls with my clients, and the best time to have a call is before, and hopefully there won't be a need for me. That's my wish for everybody. But we have a simple call, and we talk about, number one, here's my cell number. This is how you can reach me. In other words, it's good to have that information in place, and that I'm available, or any other immigration lawyer or corporate or employment-based counsel that you have. It's important that you have the toolkit in place. In the last session, they were talking about go-to people, protocol, perfect. That's great. And then what we do is we stay informed. What we're doing in terms of, and I'm not trying to sell anything, but everybody's doing this who seriously practices immigration law. We're staying informed, and we're giving briefings to our clients, briefings about how it might affect their business, briefings how it might affect their employees, because these employees have been around a long time and they're critical to the success of our businesses. And as people, we want to help our employees, we want to help their families. And that's where our and you'll notice here, our tag team approach kicks in. Ian's very much on hands in terms of the workplace. I'm very much on hands in terms of dealing with the, I wouldn't say cleanup, but the aftermath of a situation, and trying to identify what remedies or what might exist for employees. There are oftentimes, and this is one of the best parts of my job, and I'm trying to look at things in terms of positives, and not being a dreamer here, but positives. Sometimes, we have these issues we don't want to deal with, but I wouldn't say all the time, but there are times when we do consult with individuals and there's something there. And that's what I'm going to go through at the end. visit takes place. How can we help? How can we help you? We being the collective lawyer group, not just necessarily Ian and I, but the relationship with the lawyer that you have. How could we help, and how could we make the situation something to deal with, and maybe even improve people's lives? So Ian, I just want to emphasize that the setup, the preparation, the communication, the updates, being informed is so critical here.
And then it's really helpful to know sort of from the outset, people kind of use the terms interchangeably, but what is the difference between, a raid and an audit? And the raid is when usually it's ICE, Immigration Customs Enforcement, their Bureau of Homeland Security Investigations shows up with no warning, with
Oh,
a
sorry.
warrant.
Ian, are you trying to show the presentation? I believe you have a slide on that. And where it's
Oh,
on our
yeah,
end,
yeah.
it's
Is the
just stuck.
screen not? Is the
No,
screen
it's just,
showing?
yeah, it's still on the slideshow. So if you guys, I think if you want to, like I guess the first slide. So if you want to maybe
Huh.
exit and try again.
Yeah.
It's done, yeah.
Check the tips.
I know sometimes that it's has a little bit of trouble on Teams. So hopefully,
How's that? Are you seeing
yes,
it now?
perfect. Now it looks
Hey,
great.
what do you know?
Thanks
So
so
yeah, you bet. So the raid, that's, as the name implies, that's the less pleasant one. That's where they show up with a warrant to the work site. And they could separate workers from, certain workers from the rest of the population. Others present could be workers present could be arrested and detained. And at the end, the ICE agent should leave an inventory of property seized and a list of employees or individuals arrested. An audit, that's slightly different. That's where usually it's ICE serves a notice of inspection, also a subpoena on the employer requesting documents. So hopefully before ICE shows up, you've actually audited your I-9s or hired someone to review your I-9 so that you would, if this ever happens to you, you would have some sort of knowledge of what's likely to happen if ICE ever shows up. So if you come away from this with anything, it's definitely be auditing your I-9s and knowing what's in there. With an audit, they give you time to respond, generally 3 business days. Sometimes you're able to negotiate more in certain limited circumstances. For example, the HR person is not in the office on vacation, and they may give you time. They may ask you to waive the 3 days. Never do this. The first thing you should do is say, we'll present them to you in the 3 days, and then call your attorney. Because the attorney is going to want to look at the I-9s and see what potential exposure there might be. Typically, in addition to the I-9s, they'll request the payroll, current employees, and a list of former employees for the past 1 to 3 years. The reason they're asking for that is because the record retention requirements for an I-9, you get to destroy the I-9s 1 year after the date of termination, or 3 years after the date of hire, whichever is later. And then in terms of a best practice, you should be doing that. You should be auditing your I-9s periodically, getting rid of the ones that you're permitted to get rid of. And the reason is, if you're keeping the old I-9s and they're produced in an audit, you could be fined on I-9s that were incorrectly completed. Even if you could have destroyed those I-9s, even if you didn't have to retain them. So in order to reduce potential liability, you should have a record retention policy to destroy them again 1 year after the date of termination or 3 years after the date of hire, whichever is later. So the employee rights actually sort of mirror the employer rights during the raid. And again, you heard about some of this during the last presentation. So one thing I will mention, this isn't like a criminal case where counsel can be appointed to you. There is no right to appointed representation in an immigration case. So, there are some nonprofits that are providing legal services. Otherwise, the individual needs to hire their own private attorney. Bill, anything to add on this?
No, I think it's generally good in terms, and it was brought up in the last forum or presentation. The Know Your Rights is an important, it's everywhere. People are talking about it, but NIJC, National Immigrant Justice Center I saw a link from the last presentation, it's a great resource to have. And there are, it's again, not, as Ian said, it's not like a criminal matter. It's just good to know where to go in case things happen.
Yeah, and then also I'll mention on that last point, the right to argue your case before an immigration judge. Not everyone actually has that right.
Hey, don't forget
Um,
tips.
Oh, was there a question in there? I missed oh, someone just must not have been on mute. Anyway, in terms of arguing before an immigration judge, there's something called expedited removal. So if somebody's been in the country for less than 2 years, if they have certain criminal offenses or prior immigration offenses, they may be subject to an expedited removal process. But
Or
generally,
it could be a prior removal on
Yeah.
record. And that's where we're seeing a lot of our consultations and conversations now. We are advising people, and for example, to hold documentation establishing that they've been here for 2 years, so they wouldn't be subject to expedited removal. Because it's something I'm going to bring up there. Sometimes, well, there are opportunities if you're put before an immigration judge. It's not easy. You can't walk in and be put before an immigration judge. So we want to make sure that there is not expedited removal.
and that's a great point that Bill makes. Sometimes there are circumstances where we're meeting with an individual and will actually want to be put in front of the immigration judge. We may want to push it because they may be eligible for some sort of relief from deportation and be able to get work authorization based on that relief. So, these are very fact-based. Our meetings with these employees it can be an hour or longer. And we'll go into that a little bit more there, but we're, often where there seems to be nothing, there may be a needle in the haystack somewhere that we're able to find, and it requires a pretty thorough investigation of the individual's background. So how about the employer? We talked a little bit about the employee. What are your rights during the raid of an employer? Again, a lot of these mirror the employee's rights. Definitely examine the search warrant and don't let them go into any areas that aren't covered by the search warrant. Make sure that warrant is signed by a judge. They talked about that in the last presentation. Sometimes ICE will have these administrative warrants that look kind of like a real warrant, but they're not signed by an actual judge. That is not a valid warrant. It does not give them the right to enter the premises and search.
So it may be very common sense, but if we look at the employee rights, it's important. They do have the right to remain silent, but it's important there's no one resists or flees, because that could open up another type of issue, a crime of some kind. And then, Ian, most of us have never been visited, hopefully will never be visited by ICE or by law enforcement of any kind. There's a lot of pressure there. I mean, is it asking too much to say, hey, can I get my lawyer on the phone?
Nope, absolutely get your lawyer on the phone right away. They tend to, at least in my experience, they try not to push those boundaries when there's a lawyer present. Right, Bill, do you find the same thing?
Absolutely. And it's not like we're
Yep.
trying to get around anything or do anything wrong, but there's a lot of pressure here, a lot of pressure to sign things, a lot of pressure to make decisions on the spot. And that's where having another party, a lawyer on the line, you have time to gather and be properly advised. So, things do tend to operate in the way that they should if a lawyer is present, and a lawyer could be present on the phone.
Yep, yep, and make sure you need a copy of any documents that have been seized. Let your employees know they don't have to speak to the authorities.
What about signing something? I mean, you just get them out of there.
Never sign anything without talking to the lawyer first. And again, a lot of this was covered really in depth with that prior presentation. So if you haven't sat in on that yet, definitely, take a look at the recording.
And we always talk about unscrambling the egg. That's where we come in. There's that transition right now. So we're talking about it all overlaps. It's all relevant. And that's why we need to repeat. But once you sign something, once something is done, then the job becomes more difficult.
Yeah, definitely. So then there's a few different results of an audit or a raid. This is the best result. A notice of inspection results, which tells you the employer is in compliance. And if you've audited your I-9s, had a reputable company audit your I-9s, hopefully this is what will happen. Notice of suspect documents. That's where ICE has checked the employee's documents to see if they're actually valid documents and relate to them, and gives you a notice that, hey, John Smith has presented documents that aren't valid for employment authorization. I'm sorry, the notice of suspect documents is where they've presented documents that don't show they have work authorization. Notice of discrepancies is where their records, they can't determine in their records whether the individual is eligible to work. So neither one of those is really a huge issue. And then the notice of technical or procedural failures, that's where the I-9 has not been completed correctly and you need to correct it. We see a lot of those. These forms can be hard to complete. Things get put in the wrong columns. There's turnover in the HR department. So somebody who hasn't been trained may be completing the I-9s on behalf of the company. The employees might fill them out incorrectly. That happens all the time. So this is a procedural failure, is not a substantive issue. That's where, okay, this person looks like they have work authorization, but they filled things out in the wrong columns. They checked the wrong box, something like that. That usually doesn't result in a fine. Substantive issues is where, somebody presented a Mexican passport rather than the American passport in the column A of the I-9. That's where there's a true substantive issue with the way the I-9's been completed, and that can result in fines. Fines generally range from a few hundred to a few thousand per violation. So if you have 50 employees, that can really add up. Those fines can get pretty large. Previously, ICE would only negotiate the fines down by 10%. So they didn't have a lot of jurisdiction to negotiate them down. So the strategic decision was whether to take it all the way to a hearing where that administrative judge at the hearing had much more discretion than the ICE auditor and officer to negotiate the fines. So this is really kind of the real substance of what we wanted to talk about is, okay, there's been a raid, there's been an audit, and you've determined that various employees might have certain issues. They might not have any documentation, or the documentation might not relate to them. How can you help them? Definitely, we generally recommend offering leave within the company policy to let the individual resolve their immigration status. Don't make any assumptions about the individual. They may be eligible for a valid status. And don't make any assumptions if the individual shows up later with different work authorization. This happens all the time. I'll give an example where someone might show up with something different than was presented for their I-9. This is the really common case. Somebody enters the US, overstays their visa, and starts working using someone else's documents. You discover it during, an I-9 audit that this person's documents don't relate to them. They come back later with a different work authorization card and social security number. I get calls for individuals in this, by companies where this has happened, where someone has showed up with different paperwork. It's like, boy, should I assume that this new paperwork is fraudulent? Well, what may have happened is the individual may have married a US citizen, or they may have some other family relationship that has gotten them proper status in the US. So somebody gives you different documentation, you can accept that documentation. There's an exception to that. If the company has some sort of policy about honesty, that you figure out they're using fraudulent documents or being dishonest in some other way, and it's applied across the board, not just to foreign nationals, then you could consider, in that case, you're not terminating the employee because they don't have the proper work authorization. You're terminating them because of the honesty policy. You discovered that they, when they initially were hired, they had presented false documents.
Ian, if I could just
Yeah,
mention,
jump
it's
in.
something I'll touch on as well. We've heard if you have employees from Venezuela, for example, who may have TPS, which is being terminated, they may be applying for asylum.
Right.
And then based on asylum, if they're not interviewed, and I'll talk about it timely, and I'll jump in a little deeper there, they can get employment authorization. There are other circumstances in our world where, again, we tell all our clients communication is critical. You need to let your employer know that, but there are different employment authorization documents. There is employment authorization incident to a particular status where they won't have a card. So again, you really do need to understand those.
Right. So just because somebody shows up with a different identity and different cards, you don't assume that the new identity is the false one. It was probably the first one, but this is an important one for, this is what your labor lawyers would tell you. Just because somebody gets nabbed during a raid, that doesn't mean you don't owe them for work that they've performed. And if your policy, employee policies have allowed for the payment of separation pay, you should pay it. And then have phone numbers handy to be able to connect the employees to legal assistant. National Immigrant Justice Center is great in the Chicago area, World Relief, and private law firms. So, I mean, and actually, I'll mention quickly, like, another question we get asked a lot, we're advising employers, and the employer says, hey, we discovered that one of our workers doesn't have work authorization. Can you help them? They'll say to us. Generally, in those situations, we typically refer to law firms we're very comfortable with because we want to keep the separation. We're advising the employer. We're not the individual's attorneys. There could be, if we find out during the course of our discussion with the individual that, okay, they did provide false work authorization, we would have to tell the employer. Whereas if they're going to consult with their own private attorney, we can keep that wall of confidentiality up, and the employer can pay for the private attorney and keep that separation. So just, it doesn't matter who's paying for it. You could certainly help your employees in that way and get representation that will help them. Anything to add there, Bill?
Yeah, so it's if you have, for example, this is where I generally jump in terms of the type of work I do. It could be that we're not representing the business. The business typically would contact me or contact Ian and say this would be post, the focus of today, post audit post-raid. You help these individuals? And again, we emphasize, sure, I mean, what we would do is we would want to have full-out consultations with the individuals and their family members, to try to figure out exactly what it is we can do. And, you know, there's been times where we've done 20 consultations for employees, and I walked out of there where we have a dozen or so where we can help, or two. So if you work with your own attorney, you have someone in-house, you want to make sure you refer out or get a good referral from them. If we're handling your employment-based immigration, we're going to refer to someone that we believe in and trust in. And on the other end, we're also that attorney as well when someone else is representing it. So it's really important that whoever's looking at it has a full understanding, they're staying informed. Ian, do you want me to go through some of the types of benefits?
Yeah, and I'll just note, like, just lately, a lot of the calls we're getting are from Venezuelan nationals, because temporary protected status for Venezuelan is terminating. And in many of those cases, we're able to find some other option for Venezuelans. And why don't you hop into what some of those options might be, Bill?
Yeah. So the whole idea is, with these executive orders, there are things being terminated, cut off, and there are options. There's U4U, which are the clients from Ukraine. They're not accepting any more individuals who are being paroled in, but they're individuals from Ukraine who still have that status. So you have to have a heads up that at some point their plan B needs to go in place. Or it could be that, you know, we're not saying that this administration isn't going to come up with something to benefit some individuals. So we need to be open to hearing what that is. But so far, what we're hearing are a lot of remedies being taken away. So we have a consultation. We have a consultation with the family members. We've got the DACAs, the younger folks, now they're getting older, who have employment authorization. Is that going to continue? The employment authorization documents are fine now, but there may be benefits opened. Who knows? And I'll get into TPS in a second. Humanitarian options. In doing this screening, there may be ways to get employment authorization for individuals, maybe not instantly, some faster than others. T&U visas, what we consider humanitarian, someone who's been a victim of a crime, who's been cooperating, somebody who's been trafficked. That would be T. U would be the individual who's cooperating. That could lead to a non-immigrant visa and status of some kind. VAWA, that would be somebody who's been abused by a relative, spouse. It could be another immediate relative who's a U.S. citizen or permanent resident. There are ways to get employment authorization through that and permanent residence. TPS, which Ian alluded to, for Venezuela, talking to a lot of folks now who can apply for TPS from certain countries, and others where it's been taken away, notably Venezuela. Venezuela I've handled a number of cases, asylum matters for Venezuelans, but I mean, asylum essentially is somebody who's applying for protection in the U.S. based on it could be race, religion, it could be their political views, it could be social group, which would be sexual orientation. Something you can't change, it shouldn't be forced to change. And if they return to their country, they're going to be harmed. So bottom line, we ask is, are you afraid to return? It could be that they have TPS and they're from Venezuela, and it's going to end on April 7th, correct, Ian?
Yep.
But if we apply for asylum, and it has to
Oh, no,
be,
it's after April, isn't it September?
Um,
Or the extensions are good till September and the program ended April 7th.
Sure. If you apply for asylum, there are a lot of nuances. It needs to be truthful, but if the case is not interviewed within 150 days, that person can apply for employment authorization. There's a huge backlog there. The idea is we don't apply based on getting the employment authorization. It needs to be based on a fear. And there's a huge backlog, and folks who are in TPS are applying for asylum, and they have good cases, and they are getting employment authorization. relief through immigration court, that's something that Ian mentioned. If you get put before a judge, am I going to get deported? The question most people ask. Well, if you've been here for 10 years or more, you're a person who's doesn't have serious arrests, you have a U.S. citizen, child, permanent resident spouse, citizen spouse. If you can establish the hardship to them or parent, then mainly the immediate relative. If you could establish that hardship, that could lead to permanent residence, and then that's before a judge. So folks who've been here for years and years may qualify for that, and that's great. And you can get an employment authorization document through that application as well. Family-related options, stuff people put on the shelf. Child turns 21, that's an immediate relative. They can turn around and apply. There are also maybe not so easy if the individual came without a visa. We look for prior filings under 245I if anything was filed before April of that 2001. That could help. A lot of folks have citizen kids or children who are serving in the military. That's parole in place. That fixes certain issues, would allow them to apply for permanent residence. So, you know, a lot of the employees out there keep their heads down, work hard, do a great job, and have things that can help them, and they just don't want to rock the boat, and it's scary. So the whole idea is now, and we're seeing these proactively now, it's probably half the time I'm spending now is talking to individuals, families, doing FOIAs to get all the information, being very proactive, having this upfront, keeping the employer out of it. The employer pays. We don't share information. We're not being sneaky, but we're helping the employees. And these are critical workers. They're game changers, and they're sometimes our options. The key is for us to be transparent and tell them, you know, you see a doctor, this is your x-ray, this is where we could help, or there isn't anything. And there's a lot of fraud out there. Notarios, we've all heard about them. There's fraud, people coming out of the woodwork taking advantage, and that's why it's good that you get to somebody who's reputable.
Yeah, and I'll mention quickly, there may, you know, be a needle in a haystack with an employment-related option. In the restaurant industry, they're typically limited. There may be something called PERM, which involves recruiting to try to show that there's a shortage of U.S. workers qualified and willing and able to do the job. Kind of the short answer on that is that could take a number of years.
And that's where 245I would come in,
Yep. So
or
245
prior status. So it's
that's a needle in a haystack that we've been able to find occasionally. So
yeah, and you know, Ian, it helps being a little older here. Because this isn't our first rodeo, and we've been through all this stuff, this history going to 2000. Boy, 2000, I thought time was moving slowly and it flew, and it's relevant. It's all relevant.
yeah, no, that's true. We talk to younger lawyers all the time, and occasionally they're like, "What is 245I?" And we're like, "Well, that's
Pull
the
up a
needle in
chair. I'm going to
haystack."
tell you a story,
Yep.
kid. Yeah.
All right, great. And I think really, you know, a lot of this was so you guys can raise your concerns and ask questions of us, and we could be available. So I hope that some of you have questions, and we'd love to have you jump in and let us know what's, you know, concerning to you given current events.